Well, hello everyone, and welcome to this live stream session. Welcome to your employment law live stream session. I'm Lior Samfiru, the employment lawyer. That's what they call me. I'm one of the founding partners of Samfiru Tumarkin LLP. And this is the live stream session where I give you the opportunity to ask me anything. Ask me about your workplace rights. Learn about what you can do if you're dealing with a problem situation at work. I'm here at your service for you live. This is my first live stream of the year. Very excited to be here. Can't wait to answer questions. I want to be kept on my toes. I want to have 50 questions today. That'll be fantastic. I'll answer all of them. Again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and I'm live with you right now answering your questions about employment law, about workplace rights, about wrongful dismissal, about constructive dismissal, about accommodation, your hours of work, your work from home. I think you get the idea. If it's a workplace issue or question, this is the time to join and ask and make sure that you get some answers and solutions and help. This is what this is for. It's for you. So don't be bashful. There's no such things as bad questions. There's no such things as trivial issues. They're all important if it touches on your job. You work a lot. We all do. So you need to understand what your workplace rights are, what your employer can and cannot do. Now, before I get started on answering some questions, let me give you some other contact information. If and when you need to contact me and my team directly off air, off live stream, so easy to do. You just go to employmentlawyer.ca. You see that address below, employmentlawyer.ca. Contact information is right there, whether you prefer phone or email, whatever you need is right there. You can even fill out a form if you want, and we'll call you. And of course, while you're at employmentlawyer.ca, you can also read and learn a lot more about employment law and your workplace rights. It's a great tool and resource for you. Again, contact information is right there. But that's for later. Right now, I'm with you live on this live stream, me being Lior Samfiru, the employment lawyer, ready and at your service to answer questions. I'm going to start answering some questions right now. Ask yours. Don't be bashful. Don't be shy. I promise you'll get an answer and you'll be better off for it. So let's get started. Let's start answering some questions. All right, let's see. Our first question, I should say, today comes to us from Polly. My employment was terminated yesterday due to restructuring after 4.7 years of service. I was working on a mid-senior level as a mid-senior level individual contributor role and had a variable pay program of 122 base salary plus vehicle. They offered me 5 months of salary paid out, no weekly plus health and dental benefits for those 5 months, no consideration for variable pay. Does this offer looks reasonable, or can I negotiate better? So it's the question you should ask yourself is not really if the offer is reasonable. The question is it in line with your legal rights, your legal entitlements? And I can tell you that this is very likely a lot less than what you're owed. And the reason I say likely is because I don't have all the information. I don't know your age. I don't know exactly the job that you were doing. But after almost 5 years, you're probably going to be looking at somewhere around 8 months of severance. But the key here is to understand that that severance has to include all components of your compensation. So salary, commission, benefits, bonuses, car allowance, stock options if you have that. Everything that you would have earned if you'd continued working. So it's not just base salary. So right off the bat, number one, 5 months is less than what you're owed, but they're also not included everything in it. So it's actually less than 5 months because it's not a real 5 months. A real 5 months would have been all components of compensation. They're not doing that. So this is what we would call a wrongful dismissal. A wrongful dismissal simply is a situation when you're let go and you're not offered proper severance. So yeah, number of months and also what's included in it. In both respects, Polly, you're getting less than what you're legally owed. So what's the next step? Quite simple. Reach out to us. Reach out to us off air. Let us do what we do. We'll reach out to your employer. We'll get you the proper severance that you're owed. They're not going to be doing you a favor. Legally, they're required to do that. To reach us, Polly, very easy, employmentlawyer.ca. Again, don't sit on this. Employmentlawyer.ca. This is such an important question we just got from Polly because A lot of people think that when it comes to your severance, it's just about the period of time that you're going to get paid. Is it 6 months? Is it 6 weeks? Is it 12 months? That's obviously part of it. But the other part, just as important, is what's included in it. It has to include all components of your compensation. Your boss may not forget, probably won't, about salary, but what about everything else? All that has to be included as well. Thank you for that question, Paulie. Fantastic. I'm glad you asked, and you know how to reach me. Again, employmentlawyer.ca. And if you're just joining us, you've found me on my live stream. I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, with you live right here, right now, answering questions. I see more questions have come in. I will answer every single one. You have my word. So ask the question. You got time. Again, just type it in, press enter, and I'll get it popped up on my screen. I'll read it, and I will answer it. Again, employmentlawyer.ca, and I'm Lior Samfiru. All right, next question. Let's see. Fanny has our next question. I have notified my employer of my maternity leave start and end date, but they're refusing to acknowledge my end date, instead imposing on me a further date that would leave me without benefits or pay for 2 weeks. Can they refuse my requested return date and impose another date? No, they cannot, unless physically, if the office is shut down for those 2 weeks for whatever reason, so they physically can't have you in, maybe. But no, otherwise you get to decide when you return to work, and as long as you give them enough notice of it. So if you tell them today, I'm coming back in 2 weeks, that may not be good enough. They may need a bit more time to adjust. But if they've known about it for a while, they can't say, oh, too bad, that doesn't work for us, we're going to give you a different date. Okay, so the best way to resolve that, Fanny, is let us reach out to them. Once they hear from us, they'll say, yeah, of course, no problem, our bad. It's just a big misunderstanding. Of course, you can come back whenever you want. So that's what you want to do, Fanny. Very, very easy. Employmentlawyer.ca. When it comes to your parental leave, maternity leave, you get to decide when it starts and when it ends. And it's as simple as that. But of course, if you know when your parental leave is ending, give them notice. If you need to change that end date, maybe you decide to stay a bit longer, that's fine, but give notice as much as you can. Okay, you don't want to say, you know how I was supposed to come back tomorrow, I'm not doing that, it's going to be 6 more weeks. That's not going to be good. But if you tell them, hey, 6 weeks from now I was going to come back, I'm extending it now by another few weeks, that's okay. Any problems, reach out to me through employmentlawyer.ca. Again, employmentlawyer.ca. All right. By the way, if you're just joining us, you just clicked on this and you're wondering who this handsome lad is, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, answering your questions live right here on this platform when it comes to employment law, workplace rights, wrongful dismissal, constructive dismissal, you name it. This is the time and place to get answers. Type in your questions. More questions are coming in. I'm going to answer them, and I want your question too. All right, let's see where we left off. Our next question is from Anya. My employer wants to move me to the night shift after 4 years of working days. They say that my contract covers this and there's nothing I can do. Do I just have to accept? Well, obviously, I haven't seen your contract, so I can't say. I would want to see a contract. The best thing you can do right now, send me a copy of it, okay? I'll look at it and I can tell you what it does and how does it affect you. Here's why that's important. Generally speaking, your employer is not allowed to do this. They're not allowed to say, well, instead of days, you're going to now work nights. They don't have the ability to do that. That's a significant change to the terms of employment, not something that they're allowed to do, unless you signed an employment agreement that explicitly gives them the right to do that. So if you sign an agreement that says, hey, no problem, you can change my hours and my shifts whenever you want, employer, unfortunately, it's a bad deal, but you've given them the power to do that. So it really comes down to that employment agreement. And by the way, even if you sign an agreement that says that, there may be ways around it. So best advice, Anya, send me a copy of the agreement. To get my email address, very easy. Just go to employmentlawyer.ca. Again, employmentlawyer.ca. And you can send it to me. I'll look at it and I'll tell you, here's where we're at. Here's how this affects you. Can they do that? Can they not do that? All the information. But very important, that employment agreement that you signed, a lot of people, when they sign an employment agreement, they look at, what's the salary, how many weeks vacation? That's fine. But there are other important terms, like the one I just told Daniel. You know, if you sign an agreement that says, yeah, you're going to work 9 to 5, but we can change that whenever we want, essentially you're agreeing to work whatever hours, whatever days, whatever shifts your employer gives you. That's a huge problem. Or maybe you sign an employment agreement that says, we're hiring you for this role at this pay, but we can change that at our discretion. If you sign something like that, essentially you're saying, hey, employer, just give me whatever job you want and pay me whatever you want. Not a good idea. So we have to watch out for those employment agreements beyond just the salary and the vacation days. So very important. Keep that in mind. Always, I can help you and understand what you're signing, what they're asking you to sign, what they're asking you to agree to. And to reach me, very, very easy to do, employmentlawyer.ca. Again, employmentlawyer.ca. All right, live, I'm here still with you. Questions coming in, bring them in more, okay? Don't be bashful. If you ask me another 30 questions, I will answer them, okay? You're not going to leave here without getting an answer. So let's continue. Our next question comes to us from Anna. I was recruited in October into a permanent marketing role, leaving a stable job, but the company quickly revealed serious financial issues, no marketing budget, and effectively changed my role before terminating me on the last day of probation with no severance or benefits. Given the apparent misrepresentation of the role, possible bad faith, along with the financial harm this has caused, does this sound like something worth pursuing legally? Yeah, absolutely. So number one, I'd want to see the employment agreement, what it says, what it does. Does it actually put you on probation? What does it say about other things? There's potentially a claim for misrepresentation here. I'd want to discuss with you and assess that. The other thing, of course, is you may be owed severance that recognizes your service with the previous company. So there's so many things to discuss in situations where you're being recruited away from another job. So obviously that's more than we can discuss right here, Anna, because I don't have all the information. But I want you, this is so important. I want you to connect with me as soon as possible. We need to sit down. We need to take the time to review and discuss everything, all the options. I want to understand everything that's happened. You can reach me through employmentlawyer.ca. All the contact information that you need is there, phone number and email address. But man, I talked a moment ago about employment agreements. If you're being recruited from another job, that agreement is even more important. For example, if you're leaving a secure job because someone is recruiting you, why agree to a probationary term? Don't say, hey, you're coming after me. I didn't go to you, so I'm not going to agree to be on probation. You came to me. So that's just one example. Very important. If you're recruited away, as important as that employment agreement is, it's 10 times more important if you're being recruited. So please keep that in mind and reach out to me through employmentlawyer.ca. By the way, guys, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and you're listening to my live stream or watching my live stream and learning about employment law, getting to ask your questions. Questions have come in. I'm going to give them an answer right now. But hey, you still have time. This session is not yet close to being at an end. So you can ask your question and you can get an answer. You can feel better and understand your legal rights a lot more. Again, Lior Samfiru, that's me. Let's answer the next question. Carlos has our next question. What's the reasonable timing to file a human rights claim in Alberta? All facts have been given. So you generally have a 1-year limitation period. So it's not about reasonable timing, it's the limitation period. But here's the best advice I'm going to give you today. Don't do it. Don't do it until we've spoken. Okay, because there may be better ways to do that. You may be able to engage in a different process that's better, faster, more successful than the human rights process. So let's understand what your case is about, what your legal options are, because human rights may not be your best option. In fact, it may not even be appropriate. There could be 2 or 3 other better options, better alternatives. So very important that we have that discussion. And even if we decide that filing a human rights complaint is the appropriate course of action, if you're doing this unrepresented without legal counsel, you're at a disadvantage because you're going to be dealing with a lawyer on behalf of the other side. So it's not a fair fight. A lawyer against someone that's not a lawyer, you're at a disadvantage. The chances of you getting the result that you want are very small in that scenario. So let's have that discussion. Let's understand what's at stake and how to pursue it. Carlos, to connect with me and my team, we have some of the best lawyers in Alberta. Easy to do, right there on the screen .ca. Again, employmentlawyer.ca. Happy to help, happy to connect. You know what to do, employmentlawyer.ca. Thank you for that question. Very important question. You as well, of course, you can ask me, the employment lawyer, Lior Samfiru, your question right now about employment law. Let's continue. Sergio has our next question. I have a knee injury and I can't work. I drive a truck delivering and unloading doors and materials. Should I take short-term disability or apply to EI? You should do both. One is not on behalf of the other. So number one, you apply for EI. And then, yes, you also apply to short-term disability benefits. If you cannot work anymore because of a medical condition, regardless of how you got it, you have to apply to both. You may get one, you may get the other, but you must apply to both. Now, if your doctor is telling you that you cannot work, if your short-term disability insurance company is giving you a hard time, they don't believe you, they don't approve you, they're giving you the runaround, let me know. We have a whole team dealing exclusively with these issues with short-term and long-term disability. You can reach me and my team at employmentlawyer.ca. You see that right here. But you apply to both, and you apply to both right away. Okay, you'll need your doctor's support in terms of applying for short-term disability. Your doctor will help you. Your doctor would have done this 1,000 times, so he or she knows what needs to be done. So that won't be a problem. If your employer gives you a hard time with anything, let me know. I can help you with that as well. So we got your back, but I want you to apply to both, and don't try to continue working and make your injury worse. Take the time that you need, apply for those benefits, and let me help you if there's any issues. Hopefully that makes sense, Sergio. You know what to do if you need me, employmentlawyer.ca. Very easy to do, very easy to reach out. I'm here, my team's here. By the way, if you've just opened up this live stream and wondering what's going on here, well, you found your employment law live stream. I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. And I've been, for the last 17, 18 minutes, answering questions live about employment law. I'm going to continue doing that now. I'm going to answer more questions. I want yours as well. Don't leave me hanging here. I want to make sure that I help you. So ask your question, and you'll get the answers that you need. Okay, so let's continue. Next question is from Bruno. Bruno says, my case in the court is already 2 years. How much time... Where is it? How much time I have to wait to close it? All the steps are done, and the last to be is in front of the judges. Well, obviously, I don't know anything about your case, so I can't say if you're going to have to go in front of a judge or it can be resolved. The legal process can be slow, which is why a good lawyer knows how to resolve cases without having to go to court, without having to be in front of a judge. Okay, so you know it's anyone can just do some paperwork and wait to be called to court. A good lawyer knows how to be proactive and aggressive if needed to get a result. All right, so that's the key. In your case, I don't know which court you're in, so I can't tell you if you had to go to court, if it's going to be another 6 months or another 5 years. I really don't know. But if you're in Ontario, BC, or Alberta, we may want to talk about how do we get your case resolved now without having to wait. Okay, so you can reach me, of course, through employmentlawyer.ca. Again, employmentlawyer.ca. All right. By the way, before I continue answering some more questions that I see have come in, I want yours too, by the way. I want to tell you about another tool that you need to have at your disposal, at your fingertips, and that is the Severance Calculator tool. You have a right to know how much severance you're owed if you lost your job. You have a right to know if the severance offer given to you is fair. And of course, you have a right to know if you're just curious, hey, what would appropriate severance be for me? Because you have these rights, I created the Severance Calculator tool. It's free and anonymous, and you can find that at pocketemploymentlawyer.ca. See it right there on the screen, pocketemploymentlawyer.ca. And when you go there, you just click on the Severance Calculator. You answer about 3 questions, and it's going to tell you how much severance you are owed. Maybe you're owed 6 months severance. Maybe you're owed 24 months severance. Maybe it's something else. It's going to tell you and assess how much you're owed, completely free, completely anonymous. Closer to 3 million Canadians have used it already. You can use it as well. Don't be bashful. Don't avoid it. I'm very proud to have that as a resource for you, and certainly never, ever, ever sign off on that severance offer without checking out the severance calculator, pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. All right, fantastic, great. But right now, I'm still here, Lior Samfiru, the employment lawyer, live with you, answering questions. I want your question. You still have time. Here's my promise to you. If you ask your question now, you will get an answer on this session. How's that? That's my promise. Just like our next question that comes to us from Zorro. I was terminated in January 2026 for allegedly violating a non-fraternization policy by attending a coworker's wedding in August 2025. That's ridiculous. Even though I received a final warning in September 2025, I had no romantic involvement with subordinates and was simply a guest. I worked for the company for 7 years and was offered just under $10,000 severance. Can my employer rely on pre-warning incident to justify termination? And do I have legal recourse or grounds to negotiate more severance? So I can tell you, I rarely get surprised, right? I've been practicing employment law for about 23 years or so, maybe 24 years. And I don't know that I've ever seen someone fired for attending a wedding of a colleague. That's ridiculous. But here's the thing. It's actually not illegal for an employer to do that as long as they pay proper severance. So the issue here, Zohar, is not that your employer is being ridiculous and letting you go. Unfortunately, they can do that. What's illegal about this is that you're owed a heck of a lot more severance than $10,000. Now, you told me you've been there for 7 years. You haven't told me how old you are or what kind of a job you were doing. But even based on 7 years, I can tell you you're probably going to be owed no less than 6 or 7 months, and it could be as much as 12 months pay. So if they offered you $10,000, that's not even close. So yeah, this is a wrongful dismissal, not because of the reason they let you go, because you're owed full severance. So Zorro, you got to call me, man. You got to call me right away. You can do that by going to employmentlawyer.ca. All the contact information you need is right there. And of course, if you're in a tough situation right now financially, we got to do this quickly. Again, employmentlawyer.ca, and I can help you. Thank you for that. I appreciate it. Let's continue answering some more questions. Next question from Roan. Maybe it's Roan. What should I do if my employer is being racist? Do I just have to quit and hope to find another job? Well, here's the thing. Obviously, if your employer is being racist to you, that's illegal. That could be a human rights violation. You may have recourse under human rights legislation. But my first question will be, who's being racist? For example, if it's your supervisor, you may just be able to file a complaint. It's a form of harassment with HR or with the owner of the company. They have to deal with it. They have to. They have to stop it if it means letting this person go, doing whatever they need to do to stop this person from acting this way. So that's the first thing I would do. If the company doesn't deal with the problem, there's going to be legal consequences. If you can't file a complaint because maybe it's the owner of the company that's being racist, who are you going to file a complaint to? Then let's talk. What you're describing could be a constructive dismissal, meaning you're owed severance. It's a human rights violation. We can help you pursue either of those things. Of course, being in a racially charged or a racist work environment, illegal, inappropriate, unacceptable. Okay? So you shouldn't have to endure with that. File a complaint in writing if it's possible. If it's not possible, reach out to me as soon as possible. Okay, Roan, employmentlawyer.ca. The way to do that, again, employmentlawyer.ca, and I'll help you out. Thank you for that great question. I'm Lior Samfiru, the employment lawyer. More questions have come in. I want to get all of them answered before we're done here today. So let's see. Goldwork events. Terminated after 12 and a half years, no cause. So obviously you haven't said much here. Your employer is allowed to let you go with cause, with no cause, reason or no reason, as long as they pay proper severance. So the real question, Goldwork events, is how much severance you're owed. You haven't told me your age. You haven't told me the job. You're probably going to be owed somewhere around a year's pay. It could be more than that. So that's really the issue here, that severance amount. If you're not being paid what you're owed, that's a wrongful dismissal. You can reach me. Let's have that discussion. Let's assess how much you're owed and get you what you're owed. We can do that very, very easily. So Goldberg Events, you can connect with me today if you want. Just go to employmentlawyer.ca. Again, employmentlawyer.ca. I'll help you out. We'll have that discussion. I'll find out a lot more about your situation, and we'll go from there, okay? employmentlawyer.ca. All right, let's see. Let's get to some more questions. Great Gatewall has our next question. My employment contract has a non-compete. It's from several years ago, and we are under threat of layoffs now. Am I still bound by this? It would prevent me from getting much work at all. So here's the answer. First of all, great Gatewall. For most people, a non-compete is not enforceable. It's not for the vast majority of people. But that's not good enough to know that. Here's what I mean. The question is really not, is it enforceable or not? The question is your former employer going to try to enforce it? Will they take legal action against you if you breach that non-compete? That's the question. And if they are, the fact that they will lose eventually may not be much of a consolation for you. So we need to talk about that. But here's the leverage that you have. If you're going to be laid off, you're owed severance, of course. So when we negotiate that severance for you, it's probably going to be a lot more than you realize. We can also negotiate a release from those non-compete obligations so that you can get your severance and you can also work wherever you want to work. We can deal with both of those things at the same time. So if you find out you're losing your job, okay, call me as soon as possible. I'll assess your entitlements. I'll get you what you're owed, and we can also deal with the non-compete at that time. Don't ignore the non-compete. Even though you probably legally can work wherever you want, if your former employer tries to take legal action against you, it's going to be a miserable experience. You don't want that. So let's avoid that. So again, great Gatewall. To connect with me and my team, employmentlawyer.ca. Again, employmentlawyer.ca. All right, let's continue. Our next question here today is from Faisal. When you're on long-term disability, do you hold your years of service? Say you work for 2 years, and then 2 years on long-term disability is service 4 years. The answer is absolutely yes. So the time that you're on disability counts towards your overall seniority, towards your overall years of service. So if at some point down the road you're let go, when we calculate your severance, we're going to look at all years, including the time you spent being on long-term disability. Okay, very good question. So it's not just the active years, it's all years. If your employer lets you go, we need to talk, of course. If you ever have a problem, Faisal, with the long-term disability insurer, if they cut you off before they should, if they threaten you, if they don't respond to you, if they don't believe your doctor, let's talk. We can deal with them. We can get them off your back and get them to do what they're required to do, which is really to listen to your doctor and give you compensation while you're trying to get better. So thank you for that question, Faisal, as well. It looks like I'm caught up, and it looks like that's the time we have for today. I am so happy I've had this opportunity to come back here. This is my first live stream of the year. Of course, I'm going to be back. So will my colleagues. We're here pretty much every day. But you don't need to wait for that. You can reach us and connect with us easily through employmentlawyer.ca. All the contact information is there so we can have a private discussion. Again, employmentlawyer.ca. Guys, thank you as always for joining me, for asking questions, for listening and learning. My name is Lior Samfiru. I'm the employment lawyer. Always a pleasure to be here. I'll be back. See you again soon. Take care and be good to yourselves. Take care.